going concern. It may be from the resolution professional perspective because he holds the sort of fiduciary position for the corporate debtor, which affairs he is actually carrying out on behalf of the committee of creditors. Rather, I would incline to refer the resolution professional, um, you know, as a person holding a quasi court appointed position. He typically is a court appointed NCLT designated CEO of the company under resolution or potential resolution. So he has to be more mindful about his position, which is more fiduciary. And the last but the most important aspect position is from the investor's perspective because he is a person, investor, we call it the resolution applicant. He's a person who is going to pump in the money, and going to take kind of care of the operation of the company going forward. And he has decided to revive the company and take it forward. So when we see IBC, it's actually a sort of very unique area wherein a couple of practice areas are coming together and working for a common purpose. When I say couple of area means, from the lawyer perspective, we have a different practice area. I don't think a IBC can be advised by a person from a specific practice area. I'm purely talking about the lawyer's perspective. It's a combination of at least 4 practice area. Number 1 is the general corporate advisory. Number 2, I would talk about the banking finance aspect. Number 3, I would talk about the restructuring and M&A. And the 4, which is the most critical, that's a litigation. So basically a team of lawyers from different perspectives have to work together for a common purpose. And what is the common purpose? The common purpose here is to maximize the value of the asset of corporate debtors for all these stakeholders. And I just mentioned a while ago who all are the stakeholders, be it the investor slash resolution applicant, be it the committee of creditors, be it the corporate debtor, be it the other stakeholder. Importantly, I would say resolution professional. And I also understand that this seminar is being organized by IOV, and most of the, I don't know, but my understanding is that, or maybe good faith assumption is that most of the joinee participants here are the registered valuer. Let me share with you my perspective. I think valuation would play the most critical aspect throughout the course of resolution or dissolution of this corporate debtor, because at different stages valuation would be required, but the valuation perspective may differ from case to case basis. That's very important, because today if I am doing a valuation and the company is X value X, tomorrow if the resolution would have not happened, the company is going towards the liquidation and there would have been some kind of transfer disposal of the assets, the valuation would have got depleted for the obvious reasons. So I think the position, the responsibility, the role of valuer becomes more dynamic in the context of valuation. And one very important aspect which we should be mindful about is that, it's a M&A, it's a acquisitions of a corporate debtor, which is a distressed kind of, corporate debtor. It's a distressed asset. So it's not a kind of fair play area wherein the buyer or seller, here I'm seller referring to the committee of creditors, that they have enough time to come forward and discuss at length and negotiate the transaction. So that kind of flexibility we do not have. We don't have the blessings. The investor doesn't have the blessings of detailed representation warranties. He has to more rely on the contents of the provisions of IBC and in light of the relevant precedent. And that's how the role of lawyer becomes supreme critical when they represent any of the stakeholder, be it the investors, corporate debtors slash COC or the resolution professional. Now, I would also like to put it for everyone's perspective that recently you guys would have seen that on 12th of August, Insolvency, Bankruptcy Board of India, they have come forward and proposed the new IBC Amendment Bill 2025. While the bill has been approved, in Lok Sabha, now the bill has now been referred to the Select Committee of Parliament, and basis their recommendations, this is going to be placed again before the Parliament near about the winter session, which is going to start somewhere around mid or end of November. See, the aim the aim, the objective, the idea under the bill seems to be really very, kind of supreme, because they really want to modernize the IBC as compared to the, international countries. They really want to address the delay in terms of admission of the CRP. They really want to bring in the relevant concepts such as group insolvency, cross-border insolvency. They really want to bring in the concept of the creditor-led, initiative vis-a-vis the, resolution of a corporate debtor. But please don't forget the concept that the IBC still is in a evolving stage. Importantly, after the Supreme Court verdict, what all happened in the Bhushan, Power and Steel, wherein a resolution plan which was approved and in existence for last about more than 4 years got quashed by the Supreme Court, and the matter was referred to kind of liquidation basis the overarching power of the Supreme Court under Constitution. But then, having realized about the sort of havoc it may otherwise play, importantly from the perspective of the interest of the employees, who are about 25,000 more than in number, and importantly from the prospective investor who has got invested more than 27 crore in the company, it may not be a fruitful to go for the dissolutions, which is not aligned with the broad preamble of the IBC, which is the maximization of the sort of value of the asset. And that's the reason I think Supreme Court has decided to take it under review, and this is being considered at the Supreme Court level. So why I'm telling you the amendment are critical, because the amendment which are being proposed may open up new areas of litigations. If we see the IBC came in 16, effectively end of 16, for the next 3 years, 90% was litigation. Believe me, and you guys all would have seen almost 90% of those litigation would have been addressed, taken to the top level apex, and they got settled there, including what is a dispute, existence of dispute, dispute vis-a-vis the arbitration, settlement, section 29A eligibility, disqualification, so on and so forth. So I personally expect a lot of litigation going to happen, and this will give you sort of more areas, of interaction practice. And this will be again a level playing for everyone, be it lawyer, be it valuer, be it committee of creditor. And that's the reason we have to be more mindful about our conduct going forward. So I'm pretty much confident about it that this is not going to be a bed of roses going forward. It is prone to sort of litigations, and I think it will take about again a year down the line once the new law stands notified, which will take about 6 months from today. So that's the broad perspective. Importantly, let me also touch upon some aspect of valuation. See, valuation is something which is a settled principle if you talk about the judicial precedent. Court, be it NCLT, be it Supreme Court, generally, they will never go into the commercial wisdom of the committee of creditor. It's a settled principle. They will never go into, kind of cross-verifying and to ask about why you have not opted for this, or why you would have opted for this over that. But that's a area of experts who are the registered valuer, and that's a more settled principle. But as I said, valuer have to be bit extra mindful, for the simple reason that the substance of transaction, the core of the transaction, the core value of the transaction would lie in the valuation of the relevant asset, which is being acquired, which is being hived off during the CRP, post CRP, whatever. And the position is more kind of critical. Let me just put you one point for consideration. There is a concept of preferential transaction, and we'll discuss that also when we come to that side. When we talk about a preferential transactions, sort of undervalued transactions or preferential transactions, there is a concept that whenever a asset of the company is being hived out, transferred to a third person at a value lower than the value at which the corporate debtor would have acquired, it becomes a contentious issue. That's the provisions of law, by the way. If a corporate debtor is transferring an asset to a person to the benefit of related party slash creditor, which would put the transferee in an advantageous position, and the transfer value is a price lesser than the price, and this price is what? Not the fair market value. This price is the price at which the corporate debtor would have acquired. It is contentious, it is subject to scrutiny, and it may be avoided basis NCLT ruling. So I am really sort of amazed to see these provisions, because normally what happens? Normally we see a transaction should be at arm's length. When we say arm's length, the transaction should be at least at that of the fair market value. But what the law is saying, no, forget about fair market value. You have to compare the transfer price with the price at which the transaction would have, or the asset would have acquired by the corporate debtor. Just think about a situation, and this asset can be anything. Could be movable property, could be immovable property, could be shares, could be securities, so on and so forth. If just think about a situation, and that's how law gets amended, modified, given the situation. There's a corporate debtor. The corporate debtor would have invested heavily. Let's say 30-40% of its total assets would have been in form of investment in a third party, which may not be subsidiary, which may be associate, which may be joint ventures. 30%, 40% of the total assets of the corporate debtor, which is under insolvency, would have been invested, into the share security of some other entities. And those invest entity would have lost their business. There could be a business reasons, genuine business reasons, which would have derailed the valuation or the business prospect of those target entities, investee entities. Whatever happened, ABC with respect to 3-4 entities in which the corporate data would have invested, the value of the investment would have certainly, you know, sort of depleted because of lower valuation. Now today, if the corporate data would have transferred that shares to a third party in discharge of their subsisting debt, let's say a year before the commencement of insolvency, tomorrow RP can say, oh no, why you have transferred the asset, with the sole purpose to discharge the liability of your creditor, that too at the fair market value, which is all okay, certified by 2-3 valuer, by the way. But still, it is less than the price at which the corporate debtor would have made that investment. To me, this looks very illogical, by the way. To me, this looks very logical. When I would have made the investment, that too at arm's length, that too at fair market value, the target entities which were not floated by me would have got a good business. And nowadays, that, startups, early age, grown up, unicorn, they carry value basis of some business premise. If something goes wrong vis-a-vis the kind of regulatory actions or otherwise, whole value collapsed. I don't know how many of you know or know. Let me tell you, and we have been advised to many a client, day before yesterday, in last 3 days, new gaming law have been enacted. It's a clear case of value depletion. What government has done for last 3 days, they have in hurry, without consultation, enacted the new gaming law. They call it promotion and regulation of gaming law. What they have done, they have actually prohibited, while they are saying we are recognizing, promoting, regulating the e-sport and social games, online social game. At the same time, they have completely prohibited two kinds of sports. One is online games
Real
for money,
money.
irrespective, regardless whether it is a game of skill or game of chance. And let me share with you guys that the matter regarding skill of game, skill of chance is already sub judice before Supreme Court. That's number one. Number two, importantly, under the Constitution seventh schedule to Indian Constitution, rule making, law making power vis-a-vis the gaming does lie with the respective state government. In India, there have been several states which have freely allowed it. There are few states which have allowed it subject to licenses. There are 2-3 states which have banned it, like Andhra Pradesh. Andhra Pradesh and Telangana, they have banned it. Right. So this matter is sub judice. What happened? You won't believe this market. Gaming law industry is about 4.5 billion size market. It has got collapsed like anything. There have been international investors who have pumped in money into this company. Classic example of Dream 11. You guys would have been seeing the advertisement done by, in fact, Indian cricket team. Rohit Sharma, Virat Kohli, Sachin Tendulkar, so on and so forth. They have been advertising like anything. Now everything is banned. If any such advertisement happen by any person, including individual, they are supposed to be criminally imprisoned. You won't believe, if you go to the app of Dream 11, they have stopped doing play money. They have issued notification, by the way, saying that your money is safe. It will be refunded in due course. They have already done a town hall and they have done a kind of mass layover of about 15,000 employees. So that has affected. Now think about the company which value would have been about 1 billion 3 days back. Today they stand at zero. That's how valuation affect. That's how this is more dynamic. So I thought to give you a bird's eye view, and that may simply happen during the course of insolvency. When you started as a valuer doing valuation of a company on day X, when you would have been requested by the RP, sort of insolvency professional. So the company would have been sort of in a good conditions basis the assumptions, management representation you would have got from the insolvency professional. But the moment the company would have been admitted, the moment you would have the insolvency professional would have gone to the NCLT and requested for going into scrutiny of the avoidance transactions, preferred transactions, undervalued transactions, fraudulent transactions, transaction to deferred characters. Probably the valuation would have been 50% of what it would have been on day X, right? So that's how the position changes. But one thing is very important, and which makes it a significantly distinct from a normal M&A transactions. Here, the role of all the players, be it lawyer, be it valuer, be it committee of creditor, be it resolution professional, be it resolution applicant, purpose is common. We have to work together, we have to align, and we have to make it a win-win. Prime purpose remains to resolve the company with maximization of the asset of the company. That's how we have to try resolving the conflict, expressed or implied amongst all the stakeholders.